Good afternoon, everybody. Thank you for attending our sessions here with today's fair housing. I just want to do a couple of reminders before we get started. Please keep your microphones and your videos off during today's presentation to help eliminate distraction. Also, if you need a certificate of completion, please email Stacy at the end of today's presentation and she will get that sent out to you. So welcome to anybody that is new to our landlord presentations. So with that, I will turn it over to Kirsten with Fair Housing.
Thank you. So my name is Kirsten Small, and I am an investigator with the North Dakota Department of Labor and Human Rights. I have been with the department for just over 9.5 years. I've done a lot of different kinds of investigations. I've done a lot of wage and hour investigations, a lot of discrimination investigations, including discrimination in housing. So a lot of what we're talking about today, I obviously have a little bit more in-depth knowledge about what on the legal side of things, what fair housing means and what some of these laws, kind of how they play out in reality when it comes to some of these complaints that we have. As I go through the presentation, if you guys have any questions, absolutely put them in the chat. We can certainly go through those kind of as we go along, but we'll absolutely have time at the end to go through any specific questions that you have, and I'll try to provide you guys some additional information and guidance on kind of where to find additional resources, additional information to help clarify kind of the very deep depths of what fair housing is. And there's a lot of information. I know it's 2-hour presentations can always be a little difficult to sit through for the entirety. So hopefully I will make it seem at least interesting and be able to give you guys some great information as far as how we look at any sort of fair housing issues and some of those common laws that we see it violated or have concerns with that come up. So first and foremost, we're going to talk a little bit about the department. I think it's easiest to know a little bit more about what we do as a department as a whole to get a better understanding of kind of when a complaint is filed with our department, what kind of timelines you're looking at, kind of what other issues that we deal with. We'll talk a little bit about what housing discrimination is. We'll talk kind of a little bit about the just normal kind of layman's terms definition of it, as well as the legal definition. We'll talk about what fair housing laws we handle and kind of what fair housing laws you should be aware of as far as any sort of violations of discrimination, kind of what those fall under. We'll talk about the statistics and facts as far as the kind of cases that we handle, kind of case resolutions, and then we'll also talk about and common issues, common complaints that we see that come through the department, as well as common questions that we have that come up. And then we'll talk a little bit about best practices going forward from here and what to expect if a complaint is filed, as well as what are some things that you can do to ensure, hopefully, that you don't have any sort of violations happen or occur in the first place, but also if those violations occur, steps that you can take to make sure that you have the documentation needed to be able to present if there is a complaint filed. So the department itself, when I first started at the department, this is something that always kind of surprised me. I guess when I think of the Department of Labor, I always think of a much larger entity. The Department of Labor and Human Rights is actually an extremely small agency. We have currently on staff 6 full-time investigators. We have 1 temporary position investigator, and then we have a human rights director, a director of operations, an administrative assistant that kind of handles all the front end side of things for us, and then the labor commissioner. So when it comes to our actual staff, we honestly can fit at most people's dining room tables. We're a very small agency. I know, again, it is something that always caught me off guard because I guess I assumed it was always much larger. So when you call investigator frequently. So what do we do as a department? So obviously a lot of it's in the name, the Department of Labor and Human Rights, but we really have three main divisions as far as the department goes. We have the wage and hour division, and that contains all of our wage and hour laws. So things related to unpaid wages, any of the youth employment certificates or regulations as far as ensuring young employees are following the kind of work duties and hours that they are permitted to do when it comes to unpaid wages. So if an employee believes that they have not been paid their full wages or unauthorized deductions have been made, all of those things fall under our wage and hour division. The Human Rights Division, that's going to pertain to our discrimination side of things. Discrimination and retaliation is all what falls under the Human Rights Division, and that is discrimination in employment, housing, public services, and public accommodations, as well as credit transactions. The last piece or last pillar that we handle is the education and awareness. Obviously, we do a lot of presentations such as this just to provide general information about the kind of laws that we handle and ways to prevent those. But we also have information on our website. We have informational brochures. We do various booths at various events. Like I said, we do presentations for all of the different areas that we handle. So the wage and hour side of things, as well as the discrimination side of things. So when it comes to our department, these are kind of the three main pillars or main areas that we look into. When it comes to the agency as a whole, initially we actually were part of the Department of Agriculture, but now it is kind of its own entity, and it is the labor commissioner, who is kind of the overseer of our department, is an individual that is appointed by the governor. And so currently our labor commissioner is Nathan Spajovic, and he is, I believe, our 13th labor commissioner that has been appointed by the governor. So when we talk about the Human Rights Division, and we'll go a lot more in depth in regards to this, but again, just kind of some general information of the main laws on that human rights or discrimination side that we handle. So the Human Rights Act, this is going to be more of the all-encompassing piece of the law that handles the discrimination in employment, in public service and public accommodation, and any retaliation laws. That's kind of what the Human Rights Act covers, all of those pieces of it. The one that we will obviously be talking about the most today is the North Dakota Housing Discrimination Act. And so that's the one you'll see come up frequently through our discussions today, but that's obviously pretty self-explanatory. It's housing discrimination, so discrimination in any sort of housing as far as rentals, sales, those type of things. We also have the bottom two are two retaliation laws that we have. The first one being the North Dakota whistleblower law. This pertains specifically to employees that have reported some sort of law violation or a rule violation, and as a result, they were retaliated against. So for example, let's say an employee refuses to perform some sort of action that they believe is in violation of DOT laws or regulations or OSHA laws, and as a result, the respondent took some sort of retaliatory action against them, that would fall under that North Dakota whistleblower. The last one is specifically for public employees. That's the North Dakota Public Employee Relations Act. This one we do not see quite as frequently because it is a very narrow scope that we're able to look into. Basically, if an employee of a state agency files a written complaint with an agency head or the Attorney General's office, and as a result, the respondent took some sort of retaliatory action against them, that would fall under that North Dakota Public Employee Relations Act. So again, really brief overview, just so you have a better understanding of what it is that we handle. So the wage and hour, this is the piece that we see by far the most when it comes to complaints. So it's always worth mentioning because of that reason, that really when it comes to the kind of majority of cases we get, the majority of phone calls we get, they much more frequently pertain to the wage and hour side rather than the discrimination side. And that can be for anything related to wages. So it's unpaid wages, wages for work performed, hours of work issues, again, those youth employment, so those 14 and 15-year-old or under 18-year-old regulations that limit what kind of duties employees can perform. We do independent contractor verification. So we do have authority over employee-employer relationships, but we do not have any authority over an independent contractor. So if an independent contractor believes that they have been unpaid wages, they are unable to file with us, but we do have the ability to make that determination on whether or not what that relationship is truly an employee-employer or if it is an independent contractor relationship. We also handle provisions related to sub-minimum wage or employees that are being paid less than the minimum wage. And then we also have provisions for employment agency licensing. Like I said, these are kind of the complaints we see the most frequently. And a lot of times it's because, it's pertaining to wages. It's something much more black and white as far as if they believe they have not been paid properly or unauthorized deductions have been made improperly or they have not been paid out their vacation wages upon separation. It's a little more black and white to have this evidence showing I believe I'm entitled or owed this and this is the reason why. So we see a lot of wage and hour complaints filed. In the last biennium, the 2021 through 2023 biennium, we had 722 cases filed and 492 cases closed. When it's in the nearly 10 years I've been at the department, you absolutely see the ebbs and flows of complaints. Obviously, I began shortly before the oil boom started. And so I got to see kind of the influx of what occurred with the oil boom and all of the complaints that came in with that. Likewise, when it comes to additional maybe employers coming into the state or kind of various different aspects of work coming into the state, we just see ebbs and flows when it comes to complaints. So some years we certainly have more closures than openings, and other years we have more openings than closures. As far as the human rights side of things, again, this is definitely the smaller piece of what we see, but when it comes to that human rights side, it's really the discrimination. We're talking about employment discrimination, public service, and public accommodation, which means a public service would be, for example, the city water department or the police department, that they're providing some sort of service to the community. And if an individual believes that they have been discriminated against in the receipt of those services, then they can file with our office. Same with the public accommodations. It's somewhat of a similar situation. What it is if the employee, let's say, goes into a business or a restaurant and they believe that they were discriminated against in the services that they received, then they can file a complaint with our office as well. So that's what those public service and public accommodation discrimination cases are. Credit transactions. This one kind of bleeds over occasionally into the housing discrimination as well, because this is discrimination in some sort of housing or some sort of credit transaction. So it could be for a mortgage, it could be for a car loan, it could be for a personal loan, it could be anything that's related to some sort of credit transaction, and they believe that they've been discriminated against based on during that interaction. And so based on that, they could file a complaint with our office. And then lastly, housing discrimination. Again, this is the one that we're going to go into the most depth about, so I'm not going to really go too far into it right now. Of these complaints, by far, we see the most coming from the employment discrimination when it comes to those human rights. And really, it's a lot of employees believing that they've been discriminated against by their employer, by the workplace that they're in, whether it's some sort of harassment based on a protected category or requesting reasonable accommodations, or they believe that they were discharged in a discriminatory fashion. All of those may fall under that employment discrimination, but employment discrimination is the issue that we by far see the most frequently filed on. So as I stated before, we had a little over 700 cases filed for the wage and hour. As you can see, the human rights side of things is much smaller case amount. We have 432 cases filed in the last biennium and 333 of those closed. Of that 432 total, we had 308 employment cases that were filed, 52 housing cases that were filed, and then 16 public service and public accommodation, as well as 56 complaint of retaliation or that whistleblower law complaints. So as I said, you could tell just from the numbers, 308 of those being employment discrimination. That is obviously, substantially heavier than all of the other areas. So we do see the most with employment discrimination, and then housing would follow usually shortly thereafter. So what exactly is housing discrimination? Obviously, discrimination is one of those words that easily can be interpreted or evaluated by different people and have different meaning to different people. There's the dictionary definition, there's the legal definition. So we're going to kind of walk through all of those different discrimination definitions. But when it comes to what housing discrimination is, it's treating someone differently in the sale or rental of housing because of a person's membership in a protected category. So this is obviously, again, somewhat of a broad definition. We'll give you a lot more insight as to what this means. But basically, it's meaning that you are treating someone differently or behaving differently towards them in any sort of housing transaction because of the membership in a protected category. Sometimes when it comes to these situations, it's not that it's always individuals are kind of blatantly discriminating against someone or they're intentionally discriminating against someone. Sometimes some of the complaints that we see may not have had ill intentions and they may actually have had good intentions, but whatever the action was resulted in a discriminatory action. So when it comes to housing discrimination, there are fair housing laws that are enacted to basically combat any sort of housing discrimination. We have the Fair Housing Act of 1968. This is going to be the federal side of things. So this is the federal law. There's a lot of guidance on it on HUD's website. It's enforced by HUD. And then there's the state law, which is that North Dakota Housing Discrimination Act of 1990. When it comes to both of these laws, they are what we call substantially equivalent. So we have a partnership with HUD where we can investigate cases for them and they can investigate cases for us. Basically, one of the benefits of that is that instead of having two separate investigations, a federal investigation and a state investigation, or two separate complaints, it's a way for a complaint to be filed under both the state and the federal law and be able to be investigated all at one time. But with that partnership, we do have to have our laws, again, be substantially equivalent or very similar to what the federal law is. We can't have any laws that contradict what the federal law would state and vice versa. Basically, it's our laws can go above and beyond, but we can't have any laws that would eliminate protections under the federal law, and the federal law wouldn't have any provisions that would limit the ability for the state to have, again, kind of above and beyond those provisions. So obviously those are the two fair housing laws that we handle, but what do the fair housing laws do? Again, those laws make it unlawful to treat someone differently in the sale or rental because of that person's membership in a protected category. So when it comes to the fair housing laws, again, they're in place to combat any of that discrimination. And so it's basically trying to level the playing field and allow anyone to have the same equal access and enjoyments of a property, regardless of their membership in a protected category. So we talk a lot about this word protected category. So what exactly does that mean? It doesn't mean that you can, that you're tied to ensuring everyone's treated differently, regardless of any sort of prospective category. It's only these limited categories that a case can be filed under in our laws. So the protected categories on the Fair Housing Act, or the federal side of things, is color, race, familial status, which would mean basically for parents, either children under the age of 18 living with the parents or legal custodians, pregnant women, and people securing custody of children under the age of 18. National origin, color, religion, disability, and sex. So those are the federal categories that are protected categories. So basically, these categories mean that any sort of landlord or housing situation cannot discriminate against somebody because they reside in one of these categories. So they can't discriminate against someone because of their color or because of their disability. And so that's what it means when we keep talking about that protected categories. As I said before, the federal and the state law are substantially equivalent, but the state law can go slightly above and beyond when it comes to any sort of protections. So we handle and cover all of the main categories, the same ones that the federal law covers: color, race, familial status, religion, national origin, disability, and sex. But we also have additional protections that are what we call state-only protections, which means that they're not protections under the federal law, but they are protections that are in our laws and at various stages. Some of these laws are relatively new as far as protected categories, but others have been enacted years and years ago. But when it comes to those state protected categories, we have domestic violence, and this is for individuals that are basically protected under some state program. They're victims of domestic violence, and that they are participating in some sort of state program related to that domestic violence. We have marital status. This could be many different forms of marital status. So it could be that you believe you're being discriminated against because you are divorced, or it may be because you are single, unmarried, or it may be because you are married or widowed. So that's what the marital status piece is. We have public assistance. This is the receipt of public assistance. So that because you are receiving some form of public assistance, North Dakota rent help, it may be that you're receiving Section 8 vouchers, that you're receiving some form of public assistance. And as a result of you receiving that form of public assistance, the respondent has discriminated against you. And then lastly is age. And this is a protected category that's actually on the federal side for employment discrimination, but for housing discrimination, it is not, but it is covered under our state law. And what the age category it is, it doesn't mean that you're being discriminated against based on any age. It only has coverage for individuals that are age 40 and over. So that's when it comes to age, it's only for individuals that are age 40 and over. So when we look at an individual, when they file a complaint, or when we're looking at a respondent, we're looking at, is the aggrieved person a member of a protected category? As you may expect, based on what those protected categories are, most people fall in some kind of protected category. We do have, when we have a complaint that's filed, we do look at, is there a nexus or a connection between the alleged action and the individual's protected category? When we look at that, especially in that initial intake stage, or kind of those first steps of, we have somebody who's coming to us with allegations of discrimination, we obviously, again, we really clearly try to define what that nexus or that connection is. But in some situations, an individual may not have the evidence or information that would outright demonstrate what that connection is between whatever the action was. So maybe the eviction or the non-renewal notice and their protected category. So sometimes it can be looked at somewhat broadly, but we do request that there's some sort of nexus or connection in why they believe they're being treated differently based on their membership in a protected category. We also look at, is the dwelling or the housing related transaction covered under the law? So is it a rental, a sale? Is there some other form? Is it related to housing? Did they reside there or did they have some sort of housing situation going on? And then we also look at, right, initially up front, is the respondent covered under the law? So there are some various pieces that we're evaluating and we're determining, are they exempt? So that leads us to, are there exemptions from these laws? So are there exemptions from the North Dakota Housing Discrimination Act and the Fair Housing Act? Yes. The long and short of it is yes, there are a few exemptions from the law, which means that basically these laws may not have the same kind of coverage for all entities if they fall under one of these exemptions. These exemptions are very limiting, and there is going to be an assessment of it. It's not just a, we take their word for it and believe, oh, they said they're exempt under this, they must be. We do request documentation and information to support that determination. But when we look at those exemptions, there are certain sales or rentals exempt. It's also often known as the Mrs. Murphy exemption. And what that means is that is for a 4 or fewer rental units and the owner lives in one of those units. So if there are 4 or fewer rental units as a whole and the owner lives in one of them. I think one of the easiest examples, if you think of a fourplex and the owner resides in one of those units, then that would possibly fall under that Mrs. Murphy's exemption. Again, we do look for documentation and information about this. So it's not just that, yep, our manager lives in the building, so we must be exempt. It truly has to be the owner has to reside in one of those units. And so we do look up property tax lookups, various information about who owns the property. And so that true owner would have to be one of the individuals that resides in the unit, not just, let's say, well, the property manager, he resides in the unit and he does all of the managing of the property. Well, if he's not the true owner, it wouldn't fall under that exemption. There are certain religious organizations that are exempt as well. So religious exemptions, obviously, they can limit it to individuals of being only a certain religion or certain aspects, but religious exemptions, one of the kind of nuances is regardless of their exemption from those fair housing laws, they still cannot base their membership or limit their membership based on race, color, or national origin. So there are some limitations. It's not just kind of an exemption from all aspects of the law, but it does basically allow for some of the exemptions to the law, such as discrimination based on religion. Private clubs can be exempt, so kind of a members only type of thing, somewhere where there is a private club, there's restrictions, but the private club, just like the religious organizations, it cannot restrict the membership based on the race, color, or national origin. So again, they may be able to exempt people from being allowed in on the property or residing in one of the units based on other aspects, but not on those race, color, or national origin. And then lastly, housing for the elderly. There are obviously some exemptions that may exist for elderly housing as it relates to familial status or age for developments that meet the certain requirements that are set for the housing for older persons. Again, this is one of those ones where if the respondent is claiming an exemption, it's something that we would look at as whether or not it qualifies under all of those aspects. So we'll talk a little bit about the statistics and facts. So talking a little bit about what kind of cases do we see? What kind of resolutions do we see with some of these cases? So for the last biennium, which again is a 2-year period, we had 46 total claims. This was down about 10 from the previous biennium. I have not run the numbers to date yet, but I know we're pretty much kind of on par for how we have been as far as housing housing claims, so I don't see a substantial increase or decrease in the next biennium. But as a whole, we had those 46 claims filed in that 2-year period. We had, of those claims, we had 19 of them that were resolved through what we call conciliation. And we'll go a lot more in depth about what conciliation is as we go through this presentation. But conciliation as a whole is finding some sort of resolution between the parties prior to the completion of investigation. So it may be that the parties maybe they decide to end the lease, or maybe it's that they decided to agree on some sort of monetary resolution, or maybe they just decided to grant the reasonable accommodation that was being requested. We have what we call conciliation offers that can go back and forth. So again, those informal resolution or settlement offers that would go back and forth between the parties. And if those discussions are successful, then again, the case would be closed as conciliated. So we had 19 of those the last biennium. 13 were no reasonable cause, which means that we believe a violation of the law did not occur. 4 are reasonable cause. And so that means that 4 of the cases that we had in that biennium were no reasonable cause, and we do not believe a violation of the law occurred. As you can see, this was up significantly from the last biennium, as we had 0 that were reasonable cause in the last biennium, but it doesn't necessarily, it's not, again, a sign of a frequent pattern or anything of the sort. It just can be that really every situation is very different, and sometimes a violation of law can occur based on one aspect, and you could have several cases at one time just happen to be. It's not frequent that we have definite patterns or certain kind of, I guess, waves of certain types of cases that come in that are frequently cause violations. It really is a case-by-case basis. 4 of the cases we had were dismissed, and it could be dismissed for various reasons. Oftentimes, if we lose contact with the complainant, or maybe it's being pursued through court already, there might be various reasons as to why we would dismiss a complaint. Again, because we have that partnership with HUD, means we can investigate cases for them, they can investigate cases for us, and as a result, we do have what we call referring the cases to HUD. So we can refer cases to HUD for them to investigate. And if we do that, HUD also can request to have cases transferred to them, or complainants can certainly request that HUD evaluates or does the investigation as opposed to our department. But we didn't have any of those in the last biennium. We did have a handful of cases, 6 total cases, 4 of which were withdrawn with resolution and 2 that were withdrawn without resolution. These are somewhat similar to that conciliation, but it could be very informal. It may be that once the complaint was filed, the respondent reached out to the complainant and tried to remedy the situation informally without us being a party to it. That may be a withdrawn with resolution. Sometimes we have individuals who have filed and then they've decided either as they go through the process, they don't want to continue forth, or maybe they have personal things that have come up, or maybe they've moved to a different unit and they just don't want to have to kind of relive or go through that entirety of the process. Then they can absolutely request to have their case withdrawn, and we would close the complaint. They still may have legal options as far as pursuing the issue through court, but our department would close the complaint if they request us to do so. So again, of all of those cases, so the 46 cases, kind of broken down by the type of protected category that these cases were filed on. So we had 28 that were filed on disability, 9 based on retaliation. So this would be that because of them opposing some sort of discriminatory practice or requesting a reasonable accommodation, as a result, they were retaliated against by the respondent. That's what could be examples of retaliation. We had 10 that were filed on public assistance, that receipt of public assistance for various aspects. Again, it could be Section 8 vouchers, it could be North Dakota rent help, it could be some sort of food stamps, it can be related to their receipt of public assistance. 2 were filed on familial status. 1 was filed on national origin. Four of them were related to reasonable accommodations. Reasonable accommodation and disability, as you can see from the numbers, is by far the most filed on issue. And there's various reasons for that. Obviously, disability, it's such a case-by-case basis as far as the evaluation of it, and really it can impact people in various ways. There's not a one size fits all solution when it comes to disability. So we see a lot of disability cases. And if you ever were to participate in any of our presentations about any of the other categories, employment discrimination, public service, and public accommodation, you will see disability is by far the most filed on issue. And again, there's just a lot of factors to it. There's a lot of information that goes into it, and it really is a case-by-case evaluation. So, being that disability is the most filed on issue, what exactly is that definition of disability? Again, this is kind of going back to that discussion of there's a disability definition under just what the dictionary says. There's a definition of disability under what the law says. There's definitions that are for SSDI or for other aspects of whether it be some sort of benefits or any other categories. There's a lot of different definitions when it comes to disability. For the disability that we evaluate under the Fair Housing Act and the North Dakota Housing Discrimination Act, there are the three aspects we're looking at is that the individual must meet the definition under the law if they have, 1, a physical or mental impairment that substantially limits a major life activity, that 2, they have a record or history of such an impairment, or that they're being regarded as being an individual with such an impairment. When we talk about disability as far as an evaluation and any sort of investigation, or when we issue out our determinations, our written reports, our disability analysis can be pages long. And again, it really goes to that case-by-case basis, but we're looking at how that individual is substantially limited in a major life activity. So are they unable to do something that the general population is able to do, or they're substantially limited in the ability to do that function? And are there any other mitigating measures? Are there any medications that can counteract any of those substantial limitations? Are they under any sort of treatment? Those type of things. Disability is very, very broad when it comes to coverage under the law. So a lot of people may fall under disability, and it's not always visual. It's not always something that's easy to determine from the outset. And that last piece is regarded as an individual with such an impairment. This is related to kind of those stereotypes or that interpretation or evaluation of what you believe an individual may have. For example, if an individual has a family history of mental health issues, maybe they have a substantial family history of depression. And as a result, the respondent is aware of this. They believe that the complainant is distributing or displaying elements that appear that they may have disability as far as the depression goes. And so they start treating them as if they have depression. even if they've never been formally diagnosed with it. Maybe they don't have actual diagnosed depression, or they don't have any characteristics of depression, but the respondent is treating them as such. So that's more of that kind of individual interpretation on what conditions that individual may have. So it can only be discrimination if the person has a disability, right? No, not exactly. It can be treatment because of that person's disability, but it also could be people that are associated with that person. Maybe it is a mother-in-law that is staying in the unit or visiting, and that person has a substantial life activity impairment that results in them being disabled, and they're being treated differently because of it. It could be something that is just a statement out on, maybe it's a statement that's within the ad for the unit itself. It could be something within their policy that's limiting, and somebody can file on that, even if they themselves do not have a disability, but they believe that the disability, that whatever the action is impacting individuals because of disability, they have a right to file. There may be advocacy agencies that have the ability to file basically on the behalf of their mission to ensure fair housing. So it doesn't always have to be the individual themselves has something like a disability. And there are kind of a broad range or spectrum of disabilities. It's not, again, always obvious. It can be something like diabetes that is impacting their endocrine system. It may be something like a substantial heart disease condition or arthritis, something that's not necessarily always going to be visually obvious, but it may certainly be considered a disability under the law. So what does this exactly mean, and how does it affect you? How does it affect landlords or these housing situations? Obviously, we talked about the technical and the legal definitions, but what about those practical situations? How does disability truly play into kind of those day-to-day interactions? I obviously deal with the law day in and day out. I know that it can be absolutely overwhelming. Any of the legal jargon, if you ever have to go through and try to read through the HUD manual or the guidance or the laws themselves, it can be extremely daunting. But when it comes to kind of the practical use of it, the most common thing we see related to disability is absolutely going to be reasonable accommodations. There is something that individuals consistently and frequently will request of any sort of landlord or housing situation, and they can be in all forms. There's really no one size fits all, and there may be requests that you see that really are completely different from the previous ones you've received, and there's really, again, no one size fits all for any of the reasonable accommodations. So being that that is probably the piece of disability that we see the most, we'll talk a little bit more about reasonable accommodations themselves. So what exactly is a reasonable accommodation? It's some kind of change, exception, or adjustment to a rule, policy, practice, or service. So this may be any sort of request to make a change, whether that's, making a change to what they have as a practice, or maybe it's requesting an exception to one of their rules. And it's something that an individual with a disability may request in order for them to have equal opportunity to use and they enjoy the dwelling, including public and common use spaces, just the same as any other individual. When we talk about it in the employment realm, it means that they're eliminating some sort of workplace barrier in order to be able to do the job as requested, as required. But when it comes to housing, again, it's to ensure that they have the ability to enjoy the space and use the space in the same way that any other individual without a disability would be able to. So when we do look at these, fair housing laws require reasonable accommodations for individuals with disability. Really, there's only a limited selection of issues that could be why you'd say no to a request. You have to prove that it is some sort of undue hardship or that it's a direct threat. And really, you're limited in the ability to outright deny any sort of reasonable accommodation request, especially without some sort of interactive process. And we'll talk a lot more about that. So again, failure to do so constitutes discrimination on the basis of disability. When we look at these on the department level and when landlords look at these, one of the biggest things is to determine it on a case-by-case basis. So you really have to look at what's being requested and make sure that you're evaluating all of the pieces to it before making any sort of assessment. So again, it's the most commonly filed on issue in our department, but it is with HUD as well. We see tons of reasonable accommodation requests. I see them almost weekly when it comes to housing discrimination. And like I said, really any of the categories. Reasonable accommodations certainly are the most frequently filed on issues that we see. The request can be made by current or prospective applicants. It's not always going to be individuals that live or reside in the unit. Like I said, it could be individuals that may be visiting the unit. They may request some sort of exception or flex on a rule. It could be during the application process. So the individual may not actually be residing in the unit yet, or they may not be somebody who is even going to ever be a prospective tenant, but they may request some sort of reasonable accommodation in that application process. Again, it could be like an advocacy organization. It could be an organization that does some sort of testing to see what respondents' responses would be to requests for reasonable accommodations. So you really want to assess it from any point in that process. It can be from current tenants, but anyone other than that as well. So the respondent should address requests in a timely manner. There is not a set time frame. It really, again, as most of these reasonable accommodation pieces, they absolutely can be assessed on that case-by-case basis. But under the law, we're going to look at, did they make an undue delay in the process? Did they not respond to those requests? So it's very important when you receive a request for an accommodation to make sure that you're assessing it in that timely manner. Even if it just means that you respond saying, we received your request, we're waiting for an individual who's out of the office, but we're working on it. Just touching base with the individual and really keeping track of where things are at certainly can demonstrate that the respondent is taking actions and moving forward with the request in a timely manner. Requests may impact the individual's residence as well as potentially common areas. So this could be that the individual is requesting some sort of accommodation. Maybe it is in the form of maybe an assistance animal, and they need to walk that assistance animal to their unit, which would impact those common areas of the hallways. So it's not always going to be solely the individuals inside their residence or inside their unit. It can absolutely have an impact to other common areas as well. Because again, at the end of the day, we're looking at, is the individual with a disability able to enjoy and use the property in the same way that other tenants are able to, regardless of their disability? Reasonable modifications are slightly different than reasonable accommodations. These are those structural changes that are made to a unit or common areas for individuals with disability. So these are the actual changes to existing premises occupied or to be occupied by a person with a disability. So these are maybe ramps, maybe lowering cabinets or countertops. Maybe it is widening doorways. It's that same undue hardship test will apply of, is this an undue hardship? Is this a financial or administrative burden to make these changes? Are they unable to make those requested changes for whatever reason? And so, or is it in a direct threat to other tenants? So it's kind of that same assessment of the undue hardship, but it could be a variety of different things. When it comes to those common areas, it may impact those, but a lot of the accessibility pieces are going to be, they may pertain solely to the person's unit, but again, they may impact entrances, exits, those type of things as well. So the big kind of takeaways differences between the two is that reasonable accommodation, it relates to that alternation or policy of the rule, policy, practice, or service. Generally speaking, regardless of whether it's a public or private entity, the reasonable accommodation, the costs are going to be paid for by the landlord. And oftentimes in these situations, the costs don't exist. There's not usually much of a cost to permittance of a change in policy. So an individual requesting to park in a closer parking spot, generally speaking, that's not going to have any costs associated with it. If they're requesting to pay their rent on a certain time because that's when they receive their disability check, that's not going to necessarily have a substantial cost associated with it. So reasonable accommodations, the costs themselves are paid by the landlord. Reasonable modifications, again, it relates to that removal of those physical barriers. These, generally speaking, the costs are going to be paid by the tenant. So the installing of a ramp or altering the cabinets, generally speaking, the costs of those are going to be paid by the tenant. But if a landlord or a respondent receives some sort of federally supported program, if they're federally supported, then those costs do have to be paid by the landlord, not the tenant. So that's kind of the big difference between those two, is when it comes to payment. Oftentimes, reasonable accommodation, the landlord's going to be providing and paying for those alterations, whereas the reasonable modification, or that change to the actual physical property, is going to be paid for by the tenant. So accommodation and modifications requests do not need to be on specific form or in magic words. Very few times you are ever going to see an individual that comes up to a landlord and says, I'm a person with a disability under the Fair Housing Act and under the North Dakota Human Rights Act and Housing Discrimination Act. And as a result, I'm requesting a reasonable accommodation for my disability. And these are the things that I'm requesting for that disability. You may get a request like that, but generally speaking, it's not going to be always that clear and concise, and it doesn't have to be. As long as the individual is demonstrating they are making a request for an accommodation, or the accommodation request is absolutely obvious, then that's kind of that cue to start that interactive process. So we don't oftentimes get a lot of complaints where individuals say, they've worked with me the entire time, they've talked to me about this, we really are trying to work it out, but I just feel the need to file. We don't see that too often. So just working with your tenants and talking them through this process and really listening for those cues, listening for when individuals are indicating that they're having some sort of barrier because of their disability, that is an absolute cue for you as the respondent to start that interactive process. Oftentimes, respondents and landlords will have specific forms for individuals to complete, as far as, let's say, an accommodation form for an assistance animal. You may have a specific form to have the individual provide to their medical provider, have them complete it and send it back. But that in and of itself should not be an outright requirement or an expectation for the request for the accommodation, as far as if the respondent is going to say no to the accommodation because the form was not provided, and solely because the form was not provided, you'll want to look at those specific details. Because if let's say the individual's medical provider provided absolute documentation that indicates their disability related need for the requested accommodation, that may be enough for the landlord, regardless of whose form it is on. So again, it doesn't have to have that specific form or those magic words in order for it to be a true request for accommodation. So when we look at reasonable, Again, kind of this, you'll hear it frequently throughout this, that legal definition versus the practical definition. And when we're looking at reasonable under the law, it's going to be a case-by-case basis, but does it constitute any sort of undue hardship? Does it interfere with the business operation? So we're looking, does it impose some sort of undue financial or administrative burden? Are you going to have some sort of overwhelmingly substantial cost to some sort of request? Or are you going to have to hire 3 new employees to manage that aspect of the business in order to provide that reasonable accommodation? This, when we look at the both of these pieces to it, would the accommodation require some sort of fundamental alteration in the nature of the provider's operations? So does it completely change those business operations? And again, when we're looking at these assessments or these pieces, we're determining, is this actually true? So it is, let's say, for a business that has 47 different buildings, if they're saying, well, it's a financial burden to be able to provide this $100 reasonable accommodation, it's going to be very hard to indicate that that's constituting some sort of financial hardship or a financial burden on the respondent, given the size of their operation. Whereas if a small, maybe a one building, only a couple apartment facility has a request that's made that would require them to hire 3 new employees, that may absolutely constitute an undue administrative or financial burden. So when we're looking at this assessment, we absolutely are looking at the factors behind it. So if the respondent is stating, we denied the reasonable accommodation request because it was an undue hardship, you better have the documentation and the additional information demonstrating exactly why you made that decision. Because even if the answer to both of those, of does it constitute an undue hardship, does it interfere with those business operations, even if the answer is yes to both of those questions, you may still be required to provide some sort of reasonable accommodation. It may not be the requested accommodation, but it absolutely can be an accommodation that would be effective, even though it's not the specific one that they had requested. Again, we look very closely at this. So if the individual is going to use this as kind of their reasoning to deny a reasonable accommodation request, we really are looking closely at the documentation behind it. It sounds a little contrite, but working with tenants can usually go a long way. A lot of times when it comes to these complaints, we're looking at, again, tenants that are very upset with the process. They don't feel that the respondent has worked with them any, and it is a two-way street. When it comes to that reasonable accommodation process, it is truly a ping pong match. The individuals are both providing information back and forth to try to come to some sort of resolution or remedy, but having the complainant kind of involved in the process and understand where the decision's at, what decision is being made and why, sometimes can go a long way. Information and communication can be very helpful in some of these situations. Some of the complaints that I've worked with personally, it honestly came down to miscommunication or lack of communication, and that's kind of what started the initial complaint process. And so sometimes having those hard conversations, and you won't always make everyone happy, and you may still have individuals that aren't sure, what decision you made and why, or disagree with the decision that you made. But at the end of the day, just trying to work with those tenants and to kind of talk through this process can be very helpful in the long run. So now we get to the piece that I always dread. All of my colleagues always ask how these presentations go. And service animals is obviously the hottest topic when it comes to anything related to housing, whether it's ESAs or service animals as a whole. Anything related to animals in housing related to disability can absolutely be a touchy subject. So again, hopefully we're providing you guys some great information without it being too cumbersome and kind of overwhelming. So service and assistance animals, obviously as a form of a reasonable accommodation, individuals may request some sort of reasonable accommodation related to animals. Individuals who are disabled, they may require the use of service and or assistance animals. And a disabled tenant may ask their landlord for a reasonable accommodation in a no pets policy. So there may be a policy that does pertain to pets, that allows pets, but has certain parameters about it. They may be requesting an exception or kind of an allowance related to that policy. Or if a property has a no pets policy, no pets are allowed on the property, a reasonable accommodation may come as a form of requesting an exception to that policy. And again, to deny that accommodation, the landlord must prove that such an accommodation is not reasonable, not necessary, or causes some sort of undue burden to the landlord. Direct threat certainly can play into this as well, but this is something that comes up a lot. We see a lot of reasonable accommodations related to service and assistance animals. Service and assistance animals, they're oftentimes it's hard for landlords to see them as anything but pets, but truly, if they are considered service and assistance animals, they're not pets. They're more of an assistive aid of some sort, similar to a wheelchair or a walker or a crutch. And the law generally provides allowances for those exceptions to certain rules related to them. Again, it's going to be so much on a case-by-case basis, but when we're looking at these, unless the respondent can prove that undue hardship or that direct threat, really the respondent has to kind of demonstrate as to why they denied a reasonable accommodation request. When we're talking about those requiring them and allowing for them, again, there's a lot of limitation parameters of indicating, well, was it an undue hardship or not? But an accommodation request can be denied. It's just you really want to look closely at those. If you're denying a reasonable accommodation request, make sure you're really making that assessment thoroughly, because that's where we see a lot of the complaint problems, especially those cause cases. A lot of them we see kind of missteps in that reasonable accommodation process. So there are maybe various types of assistance animals, especially things like ESAs. It doesn't always have to be specifically a dog or a cat. It can be other animals. It could be ferrets, it could be birds, it could be snakes. It may not always be something that you believe is an animal that would provide some sort of emotional support or comfort, but if it is the animals that their disability related need kind of requires, then absolutely it could be requested as a form of a reasonable accommodation. So according to the joint statement issued by HUD and the Department of Justice in 2004, housing providers may not require persons with disabilities to pay extra fees or deposits as a condition of receiving a reasonable accommodation. We see this question quite frequently of, can I charge pet fees? Can I request that they pay for certain pieces related to the service and assistance animal? And basically what HUD's guidance and the way that we will evaluate any sort of complaint is, if you're going to be putting those kind of extra steps or barriers up against an individual with a disability, those are not going to be permitted, because again, the animal is acting as more of an assistive device than it is a pet. It's not considered a pet, so any of those additional fees as a condition of receiving that reasonable accommodation are not permitted. The one thing that kind of easy way, and of course this an example that people kind of will say, well, of course we wouldn't do that in this situation, but the kind of comparison I use frequently is, you wouldn't charge an individual with a wheelchair some sort of deposit on the worry that they may damage things in the long run. That it's the same kind of comparison when it comes to a reasonable accommodation request related to an assistance animal. HUD also issued a notice concerning service animals in 2013, and they actually have one from 2020 as well. HUD has at least provided a substantial amount of, I would say, very user-friendly guidance when it comes to assistance animals, obviously they are aware, just as our department is, and all of you are aware, that this is a hot topic. This is something that comes up frequently. So HUD really has provided a lot of great guidance on their website as far as their joint statement, their user-friendly guidance on kind of some of the things to keep in mind and look at when you're talking about reasonable accommodations related to animals. And we ourselves, during these investigations, the investigators all use those documents as well as guidance as far as when we're evaluating those reasonable accommodation cases. Obviously, we look a lot to past court cases, past court opinions as well, but that HUD guidance really is something that we look to frequently when it comes to determining whether or not a reasonable accommodation should have been denied or if there were any issues related to that reasonable accommodation request. So some of the issues that come up frequently when we have these complaints related to assistance or service animals, oftentimes we see things that are related to direct threats. And when it comes to direct threats, it can't be just based on kind of what your assessment is, your personal assessment or fears or speculation. It really has to have some kind of basis. It's not saying that you have to wait until an animal injures someone before you can say, yes, this is a direct threat. But again, it cannot be based on those stereotypes or kind of those all-encompassing assessments of what you think might happen, that crystal ball approach. You really have to have certain reasoning or parameters as to why you're indicating it as a direct threat. Do you have some sort of actual tangible evidence that indicates that the animal is a direct threat? Does it have a history of biting individuals, attacking individuals, those type of things? It can't just be based on a fear or an assumption that something may happen. There may be concerns related to city regulations or restrictions, so breed restrictions within a city. This is one that comes up not as much lately. I feel like a handful of years ago, we had a lot of city regulations that restricted breeds, but we don't see them quite as frequently anymore. But really, a lot of that comes down to the issues of breed restrictions on city ordinances oftentimes will come between the claimant and the city, not the landlord and the city. So the landlord should be looking at that reasonable accommodation request based on what the request is between them and the tenant, not necessarily of, well, the city says you're not supposed to have this animal, because there should be provisions in cities that have accommodation pieces to any sort of ordinance, city ordinance, just like the reasonable accommodation request process with a landlord. The same kind of process generally should happen with a public service or a public accommodation. So they should have some sort of kind of exception or process for an individual to request a reasonable accommodation related to a city ordinance. But if they don't, or if the complaint is still existent, the complaint can be filed by the tenant against the city themselves. So that shouldn't always be kind of a guiding factor for you as a landlord, because it may not be a permissible defense when it comes to denying a reasonable accommodation. Again, there may be situations where you will have to allow or work with them in common areas. The animal themselves, they can have absolute expectations when it comes to behavior. It's not that you have to kind of allow them, because they're a reasonable accommodation or a form of reasonable accommodation, you don't have to permit any and all behavior. You can have behavioral expectations and make sure that the assistance animal's under control, those type of things. But they, again, may have to have permittances to public areas, those common areas, whether it be maybe a community room or those hallways or just general spaces. It's, again, making sure that as a condition of receiving a reasonable accommodation, you don't want the individual with that disability to be precluded from participating in what other enjoyments there are for the property for other tenants. So if other tenants are able to enjoy and use the property in certain ways, then that individual with a disability should be able to as well. The requirements of animals spaying and neutering, breed restrictions, and weight limitations. Again, this is something that it's absolutely a hot topic, but when it comes to just like with the fees and the deposits, the breed restrictions, size restrictions, weight limitations, they really could be requested as reasonable accommodations of exceptions to those rules. So if a landlord has a policy that says no animal on the property of over 50 pounds, if the individual service animal is a 70-pound, you know, maybe a Great Dane or something of the sort, something that is an uncommon or very large animal, they can have some sort of permittance to requesting a reasonable accommodation to the exception of that breed restriction or weight limitation provision. So the requirements or those extra expectations, again, thinking of it similar to the requesting the pet deposit, having those additional steps saying, as a condition of your reasonable accommodation, you have to go through these certain hoops. Again, the expectations of behavior, I said it already, but you can absolutely have expectations of the animal and the provider. You can request, or the handler, you can request that the tenant ensures that the animal's cleaned up after. If they do leave at the end of their tenure and the property is destroyed, they're not precluded from having any expectations of ensuring the property is in good condition, things like that. It's just, again, those upfront conditions of additional security deposits, those monthly deposits related to pets, those can't be applied specifically to service or assistance animals. So what if another tenant also has a disability, such as allergies? That won't allow for the service animal to be in the unit. How do you assess that? You're going to want to look at this on a case by case basis. So this is basically competing disabilities. Two individuals both have disabilities and they're requesting reasonable accommodations to try to alleviate any concerns related to their disabilities. You may need to assess each individual piece on its own. You may need to assess as to what accommodation will work for both parties. So just because one party is saying, I have a disability and this is my reasonable accommodation request, just because another tenant comes in and says, well, I also have a disability, you should take my request, you may have an obligation to try to make both requests work and in kind of whatever that format that takes. This is one of the newer pieces of the law, and I always like to point it out, even though I will say we haven't had any sort of court movement on it. It's not that anyone has taken this further on to like district court or the Supreme Court to get a further evaluation or interpretation of what some of this means. But a couple of years ago, this was actually 2017, I believe, they had put through a piece of the law related to the documentation for disability or for service or assistance animals in a rental dwelling. And what the law basically states is that an individual has to have some sort of reliable supporting documentation. They can't just have kind of a sign up, just pay your fee and get a note letter. Again, whenever it has verbiage that's a little more ambiguous, like what reliable supporting documentation to me may be different from your interpretation, which may be different from a judge's interpretation. So without clear definition of what that reliable supporting documentation means, it's very hard to lean into that saying, well, we didn't accept this reasonable accommodation request solely because we didn't think that this was reliable. Well, why did you not think it was reliable? What gave it away, especially in the day and age of things like telehealth? Just because the request is from a doctor that's outside of state, that doesn't always necessarily have a huge bearing. It can absolutely be a situation where an individual is being treated by a provider in their original state, or maybe in a different state, or maybe that provider had been providing services here and had left the state. So just because it's kind of one of those out of state or online telehealth type of businesses, it doesn't automatically mean that it is not reliable documentation. So from what I've been explaining, what I've been talking about, it sounds a lot like pretty much in all situations you have to grant a reasonable accommodation. No, that's not at all the case. You can absolutely deny requests, but again, it's just under the law. Why is the request being denied? Is it that undue hardship? Is it that you had requested documentation and the complainant refuses to provide it? That you needed some sort of additional documentation to clarify what the request is, and as a result, they were not able to, they didn't provide any as additional documentation. The respondent couldn't move forward with the request for the accommodation because they didn't have all of the documentation they needed or the clarification they needed. That could absolutely be a reason why a request was denied, because there was just no response from the other party. That other party failed to engage in the interactive process or that back and forth. It could be that the request does impose some sort of financial or administrative burden. Absolutely, that would be a reason why a request would be denied. So there are situations you can absolutely deny requests. It's just, if you're going to deny a request, it's really a best practice to ensure you know exactly the reasoning behind why the request is being denied, and really look at those federal and state laws to determine, is this permissible under the law to deny this request for the reasons I have? So again, that undue hardship, does it impose that undue financial or administrative burden? Would making the accommodation require some sort of fundamental alteration to the nature of the provider's business? And again, even if both of the answers to these is yes, you still may need to be able to provide some sort of accommodation. There may be alternative means. Reasonable accommodation requests do not necessarily need to be the accommodation of the individual's choosing, but they do have to be effective. They have to ensure that whatever accommodation request is put into place, that it is effective for that individual's disability and eliminates those barriers. So again, when we're talking direct threat, we're talking about, is this, it can't be excluded, or you can't say no to a request solely based on your fear, speculation, or stereotype of that particular situation. It has to have some sort of reliable, objective evidence. So current conduct, recent history of overt acts. We're going to look at what the nature, duration, and severity of the risk of injury. Again, you don't have to let a situation occur in order to prove that it's a direct threat. But if you're going to deny a request based solely on a direct threat, you really want to assess that the reason you made that assessment wasn't just because you were concerned about it or you speculated something might happen, that you actually have some sort of evidence behind why you made that decision. So again, the nature, duration, and severity of the risk of injury, probability that injury will actually occur, and whether there are any reasonable accommodations that will eliminate that direct threat. So can you ask for documentation related to a reasonable accommodation? Maybe. When it comes to any sort of documentation, when you're looking at a reasonable accommodation request, you may need to get information to confirm that they are a person with a disability, that they have some sort of limitation, or that they need some sort of modification or change, and shows the relationship between those two. If you have documentation that shows, yes, I believe this person is a person with a disability under the law, I do believe this requested accommodation would be effective for their disability, and that may be enough right there. 2 sentences may be enough indicating, I've assessed what exactly this person's requested. I know that they have a condition that needs it, and here's the documentation. They absolutely need this accommodation, in my professional opinion. So if you have that, oh, sorry, we got a lot of, if you have that information, really, it's going to be something that it's going to be hard to ask for clarifying information, because you have that true evidence that the individual is a person with a disability and explains exactly what that disability related need for the request is. But again, you can certainly ask for additional documentation to help clarify what they're requesting. If the information that they've provided is vague, ambiguous, does not explain the disability related need for the accommodation, you may absolutely need to request additional information. But again, do not act in these situations as the medical provider. You aren't the one that's making the assessment on whether or not they should or shouldn't have this accommodation, or whether or not you believe that their conditions require it. Really, if they've provided you documentation that shows that disability related need for the accommodation, generally speaking, unless there's some sort of undue hardship, it's going to be difficult to deny that accommodation. So again, if the documentation received for an accommodation request is not clear, you may ask for additional documentation that verifies that presence of the disability, explains that specific connection. It's absolutely something, if it's not clear, you can ask for additional documentation. But what we really look at here, and what HUD's guidance will go off of, is if you were provided the information that does show that connection, to continue to prod and ask for further documentation, that may be problematic. So again, major things to keep in mind when it comes to accommodations. It's not always going to be those clear and concise statements or on a prescribed form. Just know that there at any point can be a reasonable accommodation request, and kind of have it flag in your mind of a request is being made. I identified that they are indicating some sort of disability related need or alteration, that they've requested some sort of change, and kind of have that as a flag in your mind to start that interactive process. Respond promptly. Again, making sure that you are going through those requests in a timely manner, because you not providing responses or providing those undue delays, that in and of itself can be deemed as a failure to provide a reasonable accommodation. So you do want to engage with that interactive process and really work with the individual in moving that process forward. We say to think about the dance when it comes to reasonableness. So disability. Does the tenant have a disability as defined under the laws? A would be accommodation. Is the tenant requesting a change in the landlord's rules or practices? N is it necessary? Is the accommodation or the modification necessary for full use and enjoyment of the property or of the unit? Cost. Does the accommodation or the modification impose an undue financial or administrative burden or cost to the landlord? And then lastly, effect. Would the accommodation or the modification affect a fundamental change in the landlord's business? So if the answer to those first three pieces is yes, and the answer to the last two is no, then you should grant that request. So as long as it's not causing that undue hardship in some way, then really the request should be granted. And as soon as you determine a request is being made, make sure you kind of stop, hesitate, and start taking notes. Start listening to what they're saying, what they're providing. Again, kind of working with that tenant is going to go a long way. Just being responsive and really talking through the process will absolutely help that process go smoothly. One thing to keep in mind a lot, retaliation. It is the action of harming someone because they have harmed oneself, or revenge. This is something that we see come through the department a lot, and it can be in many forms, but in kind of the scheme of talking on reasonable accommodations, just really ensuring your staff and yourself know that retaliation is not permitted. So if an individual requests some sort of reasonable accommodation, or maybe they participated in some sort of investigation. Maybe they filed a complaint with our department in relation to discrimination. As a result of those actions, the respondent should not take any sort of retaliatory action against that individual. It is and absolutely can be something that's kind of just a human reaction. You may feel slighted. You know that whatever the allegations are, you don't believe that they're true, or you believe, especially this comes up a lot when there's allegations of maybe harassment or discrimination, and the landlord or the manager goes, that's not at all what happened. I didn't do that. I didn't, I didn't say any of that. And as a result, they're personally slighted, and their kind of natural reaction, their defense mechanism may be to lash out or respond to that individual. And that may cause for retaliatory allegations. So the individual sometimes can believe that there was malicious intent and they'll want to defend themselves. The accusations can be very serious. It can be very daunting receiving a complaint from the department that indicates these kinds of allegations. And so they may naturally have that human reaction to want to react to that. They don't necessarily always see it as bullying. Bullying they don't see necessarily as a form of retaliation, but absolutely we can have complaints of hostile environment harassment because of retaliation. So the forms it can take, it's obviously it can be actual tangible items. So they believe that they were being evicted because they had participated in that protected activity, because they had requested that reasonable accommodation or filed with the department. But it could also be that they believed that they were being harassed. They believed that they were being targeted because they had made those reports. So moving into publications a little bit, this is something that we do see, not necessarily frequently, but we do have coverages for specific discriminatory statements or pieces cannot be put into publications. And it's not always what you necessarily think of when it comes to publications. So the law itself states a person may not make, print, or publish, or affect the making, printing, or publishing of a notice, statement, or advertisement. It's about the sale or rental of a dwelling that indicates any preference, limitation, or discrimination because of a person's membership in a protected category. Again, in this day and age, this isn't always just the newspaper. It's easy to think of printing and publications being kind of those newspapers, magazines, but in this day and age, it can be social media posts, it can be memos, it can be text messages, it can be just general conversations, especially being that almost every single person has access to recording devices through their phones, through their smartphones. They can really have any sort of recorded conversation at any point. So even just verbal discussions can absolutely have more documentation than they even did 5 to 10 years ago. So again, when we talk about those examples of publications that published in newspapers or other media, any written statements, verbal or nonverbal statements, again, they're not always ill-intentioned, but they can show a preference or a limitation. So if an individual, let's say they just went through a really terrible situation and they are just talking to another tenant about it and they go, I just had a bad situation happen and this is why I would never rent to bachelors again. There's no way I would ever rent to a single male again because I just can't stand this. That can be a statement that shows a preference or a limitation to individuals based on a marital status or based on a gender. So those in and of itself, they're not always ill-intentioned, but they absolutely can show that preference or limitation, saying, we don't want anyone to rent here if you receive Section 8 housing. That could be indicating you're putting a preference or a limitation on individuals with the receipt of public assistance. So again, they may be well-intentioned, but not always legal. It's not that we see a lot of blatant negligence. Sometimes it's just landlords, either maybe they're speaking to their tenants or they're just trying to prevent issues from occurring again. But again, they may not have ill intentions with it, but it could be not be permitted by the law based on just what that law is. So again, there's some of those exemptions from publications, just the same as we had talked about before, those housing for older persons, those private clubs and religious organizations, and then also shared living houses, things like dorms. They may certainly have kind of that publications limitations on they only request females, or they may have certain limitations that speak specifically to shared living housing arrangements. When we look at what that reasonable person standard is, so when we're determining whether a publication constitutes a discriminatory practice, the courts and our office have generally applied that reasonable person standard, which means that basically an ordinary reader or listener is going to gather from that conversation or that publication that there is some sort of preference, or that the preference is readily apparent. So basically, it can obviously be subjective, and we absolutely look to past court opinions, past court cases, as well as kind of get legal opinions from our side of things, which is the Attorney General's office provides our legal decisions. And so we absolutely touch base with them. But we're really looking at, is what they said, could an ordinary reader or listener gather from that conversation that there was some sort of limitation or preference based on a protected category? So if an individual says, I don't like Tuesdays, that's not going to likely come off from somebody else that there's some limitation or preference or indication that they don't want individuals of a certain protected class participating in applying for their units or residing in their units. That's not going to be necessarily something that's readily apparent to an ordinary listener as some sort of limitation. Whereas again, the previous example I gave of I'll never rent to a single male black bachelor again, that can absolutely indicate some sort of preference or limitation. So some of those terms to avoid, again, looking at these, a lot of these, when you read them, you think mostly of those actual true publications. So writing, the description of the property and you're seeking new tenants, or maybe you're putting a post up on social media of what the property is, trying to avoid some of these terms, the adult, bachelor, couple, no children, Christian, single, handicap, integrated, those type of things. Some of the other ones, membership, approval, mentally ill, race, physically fit person, all of these things can absolutely be perceived potentially as they only want certain individuals in that unit, that they only want certain individuals to apply, or that they will only select certain individuals to reside in that unit. You being cautious of emotionally charged conversations with tenants is always kind of a good idea, because whenever you have those emotionally charged conversations, saying things that can just off the cuff that you are just upset in the moment and saying can absolutely come back to haunt you when it comes to these discriminatory statements. And again, it's not always that they were outright negligent in kind of flippantly violating the law, but if they do indicate that limitation or preference based on a protected category, it absolutely can be problematic. So biggest rule of thumb, in general, when you're advertising the sale or rental of a property dwelling, describe the property, not the person you'd like residing in it. So it's, again, those trying to just be aware and cognizant of what conversations you're having with tenants, what you are posting on social media, making sure that it really isn't showing some sort of preference based on a protected category is going to be your absolute rule of thumb and kind of best practices to go forward with. So anyone who believes that they've been discriminated against has a right to file a complaint with our department. It can be extremely daunting, especially if you've never handled a housing discrimination complaint. All of a sudden, you receive this complaint in your mailbox asking for you to respond to these discrimination allegations, and it may completely catch individuals off guard. It's not that they necessarily knew it was coming, but what do you do? What do you do if you receive a complaint notification that a complaint has been filed with the department? Now what? So I'll walk through a little bit about what that process is. Again, really giving you guys good insight as to what this process looks like. First and foremost, to hopefully make sure that it isn't as daunting. It's absolutely a serious process. There's, there's serious ramifications. We're obviously evaluating if discrimination occurred or not. But at the end of the day, it's a process. It just is a process that's followed, and it's something that at least having a little bit better knowledge of what that process looks like, in my opinion, can always help just alleviate some of those concerns about what to do when a complaint is filed. So the first step is, again, any individual that believes that they have been discriminated against, they have a right to file a complaint with our office. So they would file what we call an intake, and that just is kind of a write-up of what they believe occurred, how they believe that they were discriminated against, and explains the particulars, explains who the complaint is against, what their information is, kind of the initial application or form, if you will, of a complaint with our department. Once we receive that complaint form, it is assigned to one of the investigators to kind of do that preliminary evaluation of the information. So we're going to determine, do we have jurisdiction to take this complaint or not? So did the complaint happen within the statute of limitations? Statute of limitations for a housing complaint is 1 year. So we can look 1 year back from the date that the individual files to determine if a violation occurred or not. So let's say I was evicted 18 months ago and I file, I will not, that's not going to be timely filed because the incident didn't occur within that statute of limitations. When it comes to jurisdiction, we're also evaluating, again, some of those exemptions. We're looking at whether or not the individual, the respondent, let's say, has the respondent has resided in North Dakota, or that the tenant has, the situation has occurred in North Dakota. We then evaluate, again, whether or not there's that connection or the nexus. So the allegations that they're saying occurred, if true, did it constitute a violation of our law? If they're saying, I believe I was evicted based on my race, and what is that connection between that race allegation and them being evicted? Again, they may not have all of the information up front, so it might be something that they end up having to, really go further in depth about why they believe it's a connection. But they may not have that information up front, so it may be enough to file that complaint initially.
Kirsten, can I interrupt you for just a second?
Yeah.
Whoever's on the iPhone, can you please mute and take your video off? I can't mute you for some reason. And there's some background noise. Thank you.
Thanks, Kylie. So once we receive that complaint, once we've established jurisdiction, then we write a formal complaint. So we write basically a summary of what the allegations are on our prescribed form, or kind of it really is just a Word document form that indicates this is who the complaint is filed with, this is who the complaint is filed against, this is the dates of the allegations, this is a law that it falls under, and this is a summary of what they're alleging happened. So we try to keep it fairly short and concise and really get to, I believe I was discriminated against based on XYZ. Once we have that summary or that complaint put together, we send it on to the complainant to confirm everything's accurate and correct. If it is, then they go ahead and sign the complaint and return it to our office. Once we receive that signed complaint, that is what officially opens the complaint with our department. So until we receive a signed complaint, even if they filed an intake, even if they've been in correspondence with us, until we receive that signed complaint, the complaint is not open with our department. But once we receive that signed complaint back, That's what officially opens the complaint. Then we send the complaint on to the respondent to provide a response. When it comes to housing investigations, generally speaking, even if the complaint is just being filed against, for example, a landlord or property management company, when we do the naming of the respondents or who all the parties that are involved are, we do name the owner of the property. We oftentimes get a lot of correspondence back saying, well, we just own the property. We have nothing to do with those day-to-day operations. But under kind of the legal umbrella, the responding, even though they may not have anything to do with those day-to-day operations, they have a play in the situation because they actually own the property. So when we look at who's named as respondents, sometimes those are some of the questions that we receive is why this individual was named, and that's why. It's because it can be anyone who was involved in the complaint and involved in the property itself that had the situation or the allegations occur at. So it can also be individuals. So it could be the management company as a whole and the specific property manager or a specific maintenance employee, a specific individual that they believe that person had some sort of hand in the discrimination that occurred or failed to respond to something that occurred that was discrimination. So once we send that on to the complainant or the response onto the respondent, we request a response from them. We request their side of the story. When it comes to these investigations, the department always acts as the neutral party. We're just the middleman that is determining whether or not, based on the facts and situation, if a violation occurred or not. And so basically our first step is we have the side from the complainant, then we request the side of the respondent. So once we receive that formal response, that's when we actually start investigating the allegations. We perform additional interviews with the parties. We gather additional evidence. We gather what we call comparative data or information about, for example, other tenants that were in similar situations, maybe other tenants that were also evicted, maybe other tenants that had applied and were selected for the unit versus the complainant who was not selected for the unit. Basically to evaluate whether or not what the response is from the respondent, if the evidence truly shows that as well. So those are some of the things that we'll do during an investigation. Once we believe we have all of the facts and information in order to make a determination, then we issue a determination on our findings. That is basically just a written report. It's a report explaining what occurred in the investigation, what we determined, and whether or not we believe a violation occurred. When we do that, we issue it to both parties, and I'll kind of walk through what those two options, once we make that determination, are. But that's kind of the outset of what that investigation process looks like. We do emphasize conciliation throughout the process. So either party can absolutely make any sort of possible resolutions, propose any resolutions throughout the process, all the way up until the point we issue the determination. And if we believe a violation of the law occurred, even thereafter, the parties can absolutely try to resolve the issues. These are just informal negotiations. You can absolutely schedule something like a formal mediation, but a lot of times these conciliation offers are just really general informal conversations back and forth, explaining this is what I'm seeking to try to resolve the issues. And then we'd pass that offer along to the other party and back and forth in hopes to try to resolve the issues. They are confidential. Either party can absolutely have representation during these discussions. It's up to them. They don't have to, there's no requirement to do so. And all of the agreements are absolutely voluntary. So there's no obligation by either party to accept conciliation offers, or likewise, there's no obligation by either party that they have to make conciliation offers. It is something that we're required to emphasize throughout the process, but really it is up to the parties. It is a great way to try to resolve the issues, really knowing the outcome. Because obviously, once the determination is made by the department, it's all just based on the law and the facts and evidence. There's no real say from either party on what that outcome is. It's just the department's evaluation of the facts and the law. And so I think, conciliation is always a great option for either party, even if it's just to explore possible remedies or resolutions prior to the completion of an investigation. So once we complete that investigation, like I said, we issue what we call a determination. And that determination either determines based on the facts and evidence, we believe a violation of the law did occur, in which case we would issue a charge. Basically, it's a charge indicating that we found that the respondent did discriminate against the individual or the individuals, depending on what the situation is, in violation of our laws. And so we would issue that charge, and then really there would be court proceedings thereafter. If we believe, based on the facts and evidence, a violation of the law did not occur, then we dismiss the complaint. We issue that determination out, then we would dismiss the complaint. The complainant may have district court options thereafter, but the complaint would be closed with our office. So there would be no further action with our office. Again, the department itself, we act as that neutral party. Our job as investigators is to conduct a fair, impartial, and thorough investigation into the facts and circumstances of the complaint. And we collect that facts and circumstances to determine, did a violation of law occur or not? And exactly, how did we come to that conclusion? Again, we do a lot of investigations, with a lot of research into past court opinions, past court cases. We get a lot of guidance from HUD and just, again, past court situations that have occurred in our realm, in our state, as far as housing issues. And it's a way for us to really make that determination on if a violation occurred or not. So what's the easiest way to avoid complaints? Obviously, knowing the law, getting educated, it can be very helpful in understanding exactly what the guidance is out there. What are your expectations as a landlord? Like I said, the HUD's website has some great fact sheets as far as their service animal, the 3 different forms that they have of service animal documentation. Very helpful. And I would say of many government forms, their most recent one that came out in 2020 is very user-friendly, very question and answer, if yes, go to this question, that type of thing. So it's very helpful. But if you don't know or aren't sure on how to respond to a complaint or what's being asked for a reasonable accommodation request, don't just assume that you are making the right decision or not. Seek the advice from a knowledgeable attorney. That's one thing that our department will always provide you kind of guidance as far as where to look or what information or what laws we have, but we can't give any sort of legal opinions. We can't give any sort of advice. So your best bet is absolutely going to be going to an attorney that is knowledgeable in fair housing laws. It's the easiest way to make sure that you really are following the steps you need to in order to make the right decisions. Also, document everything. In a day and age, again, of documentation is everywhere. It is absolutely crucial for you to maintain good records, whether it be memos to tenants or even just email correspondence or text message correspondence with tenants. It's very helpful if a complaint is filed to be able to have that backup documentation to really demonstrate what your side is and what position you took and why. Avoid those sudden rash decisions. Just because an individual is saying something that seems outrageous or outlandish doesn't mean that the instant response should be no. Always think about those reasonable accommodations and that interactive process. You really want to get all of the facts and information before you make that sudden judgment or that sudden statement, because again, all violations are not necessarily outright plain language kind of they're not something that's as easily seen as, oh, I knew I was doing something that was against the law. I'm just going to do it anyway. So really making sure you're stopping and evaluating the information before you make those decisions can absolutely protect you when it comes to some of these complaints. Train your managers and staff, especially those that are dealing with the directly with the public. Any individual that is having dealings with the public, you're really going to want to make sure that they are knowledgeable on what some of these issues are that come up, to make sure that they're not making those sudden and rash decisions, or if a reasonable accommodation request is being made, that they can identify that and they can bring that to the appropriate parties and move that forward. So any individual that is dealing with the public, you really should have them be aware of what some of these fair housing laws are and be able to just at least identify them, to be able to protect yourself as a company, but also to bring that information to the right individuals to be able to move forward with things. So, for example, a reasonable accommodation request, you really want to make sure that they get addressed in that timely manner. So if your team knows that, yep, I'm identifying this as a reasonable accommodation request, they know where to take it, it really streamlines that process. Again, know the law, but if you don't, contact an attorney. Make sure that you contact somebody who is going to be able to provide you some of that advice and guidance and practical applications to what's happening. It's, as I said, when it comes to especially disability discrimination, every situation is absolutely unique. There's not a one size fits all for everything. And so really making sure you are handling every situation and every request in the best way you can, again, will really prevent any sort of concerns or issues in the future. Be consistent. So if you have a practice or a policy for tenants to do certain things, making sure you follow that practice or policy, making sure that you really are following your guidelines, your policies, your practices, as far as being consistent with tenants, will go a long way. And then lastly, be nice and communicate. I've said it several times, but really one of the big things is having that consistent communication with tenants, or at least having them be kind of part of that process. It's not going to resolve all issues. It's not going to prevent any issues from ever happening, but it absolutely will help them understand where you're at with things. Sometimes we have complaints that are filed by individuals who solely really are just frustrated with where things have gone, what the reactions were. And there may be a lot of workings that are happening kind of behind the scenes, but the tenant doesn't have any knowledge as to where things were at. They haven't heard anything in months, so they just assume the respondent stopped reacting or stopped being involved with that process. So with that, I would say that's all I have, but that's a lot of information. Like I said, we have some great information on our website. We have great information on HUD's website, but we absolutely are friendly faces to chat with if you have questions. Again, we can't provide any sort of advice or guidance, but absolutely we try to point you in the right direction. At the end of the day, as you see from our claim numbers, I'm thoroughly employed. We don't have any fears that no cases will come to us in the future. So really trying to help you guys know the law up front to be able to respond to these cases and try to prevent them from occurring in the first place really is something we very much try to help you with and try to provide you guidance.
Thank you. There's a large scenario in the chat, so I think I'll just let you read that and then answer as needed, just so it's easier for you to understand.
Sure. Let me find it here. So I'm going to respond, but I feel like there may be additional questions that are associated with it also. So please let me know if I'm not responding to it completely or fully. But basically, the question is related to, I believe this is maybe there's a longer scenario in there also, but I think this is the one that it's talking about an ESA or a pet that was basically snuck into the property. And then there was kind of that interactive process when the individual requested it as an ESA, and there was back and forth with the respondent requesting additional documentation related to the ESA and kind of asking what's an appropriate timeline for that. So this is going to be one of those case-by-case basis situations. It really is going to depend a lot on what that initial note provided or not. You know, did it provide that the individual is a person with a disability and there's a disability related need? Because that may be enough potentially. If it really didn't provide clarification as to the medical necessity or what was being requested, absolutely, you can request additional clarification. You can request additional documentation. As far as a timeline goes, again, this may be something that would be fluctuant. So you can absolutely request it in a certain period of time, but if the tenant comes back and says, I'm unable to get to my provider for a month, that may be an extension. That in and of itself may be a request for an accommodation for an extension. So the respondent would have to evaluate, is there some sort of undue hardship and us letting him wait a month before they provide that note? It could be also that they maybe if the landlord said, okay, well, this note's not good enough, you need something further, you have to provide it by 5 p.m. today. We may evaluate that and say that's far too limiting of a time frame. It's an unreasonable amount of time for the tenant to provide that information. And so by their actions, basically that they're denying a request for an accommodation because they're putting kind of those undue steps ahead of it of saying, well, you didn't provide it fast enough, you have to get out. So there's a lot of pieces that may come into that. I don't know. I hope I answered most of that question, but I know that it's just really going to be a case by case basis. And there's absolutely factors that may play into it that, again, maybe things like additional reasonable accommodation requests. And there may be, let's say, situations I've seen where an individual actually has a pet. It's a pet-friendly building. They have a pet. They have pet fees associated with it. And then over time, they do request it as an ESA, and then they request those pet fees be refunded. That can be a form of reasonable accommodation because the animal is no longer a pet, so the pet fees do not apply. So there's kind of a lot of pieces. As I said, when we started the service animal and assistance animal part, it's always just such a tricky situation. All of the situations that come up with pets in general, they tend to be really a lot of the reasonable accommodation requests we see are related to pets and ESAs for the most part. So please let me know if I didn't answer all of the question, please.
Are there any more questions for Kirsten?
And as I said, absolutely reach out to us, whether it be to me personally or just to the department as a whole with any questions. Myself and all of our investigators and our admin are absolutely here to try to put you in the right direction. So even though we can't provide you absolute advice or yes or no answers to questions necessarily, we really are there to hopefully try to help guide that process and give you the information and tools that you need to be able to make those decisions.
All right. Well, with that, just a reminder that there will be a survey sent out again, either later today or tomorrow. Please provide any feedback and possible topics you would like to hear about. We do have a couple openings still for this fall/winter session. Also, if you need a certificate, please email Stacy and she will get one sent out to you. Next week, we have Heather Ingman and Darianne Johnson presenting on VAWA, Violence Against Women's Act. So hope you can join us next week. And the recording might be iffy here because I lost connection. So hopefully we'll have a recording sent out for those that either had to leave early or if you have coworkers that weren't able to attend. So hopefully we'll get that taken care of as well. Thank you and have a great day.